All right, call our meeting to order. Good morning.
Good morning.
We are going to, I think, circle back to some of the places that we had questions. I know Chris is here to help us with the things.
I hope.
Of course.
I'll try.
I think Kate McCarthy's coming.
I got a text, she is.
With interchanges, yeah. Okay, so we just made a plan, and I don't.
Sure. Ellen Czajkowski, Office of Legislative Counsel. I think where we left off yesterday, the only section we hadn't at least talked about was on the very last page, page 31 of your side-by-side burden of proof. And these are very close. The two options you have before you are very close. So currently, your committee bill, we're talking about section 6088 of the statute, and it's the burden of proof. So the committee bill has a proposal to clarify the language a little bit that we talked about the other day. So initial burden of production has been pulled out from burden of persuasion. And the burden of so the applicant always has the burden of production because they have to prove that they've met all 10 criteria when they submit their application. Burden of persuasion, to show that it meets the relevant standard, is on the applicant for criteria 1, 2, 3, 4, 8A through C, and so that's aesthetics, forest blocks, and connecting habitat, 9 and 10. And then the burden is on the party opposing the application for criteria 5, 6, 7, and 8, not including A through C. And so, I misspoke. So A is aesthetics. Sorry, let me. 8 criterion 8 is aesthetics. Criterion 8A is related to necessary wildlife. 8B is forest blocks. 8C is connecting habitat. So the joint proposal is only slightly different, and it is slightly different because they rearranged the existing criterion 8. And so the only difference between your bill and the joint proposal is that they moved rare and irreplaceable areas to be a part of 8C. So in yours, that is, the burden is on the opponent, and in theirs, the burden is on the applicant. And that is the only difference between the two proposals, I believe. So we're talking about a very small.
And it's the necessary.
Rare and irreplaceable. Because they rearranged 8 a bit. And it doesn't match. It doesn't line up with yours exactly.
But the burdens also don't quite line up.
No, the other burdens do. It's just rare and irreplaceable that is different in your two proposals.
So it's not connected, it's rare and irreplaceable.
I can't hear you.
I'm just trying to get clarity. I thought you said C was connected, but you're saying it's rare and irreplaceable?
So they rearranged it. Let me see if I can find you the exact language. So here on page 9, we have the side-by-side of your two criteria 8 proposals. And in the first section, they strike rare and irreplaceable natural areas and move it to be part of their new 8C. Which is different than your 8C.
So it seems to me if that's the only difference, and the rare and irreplaceable part of 8C puts the burden on the applicant, but that's okay. That's not supposed to. That's the only difference.
Yeah. I mean, yours also adds the new language about separating, highlighting burden of production versus persuasion. But the substantive sort of,
You think the wording is more clear with this calling out the burden?
that's really a decision for you, because that is a difference that they didn't address, is whether or not the production and persuasion should be called out separately.
I think calling it out separately makes it clearer for everyone to see. And could we just insert that into the joint proposal?
Well, we could, but
Yeah.
let's talk about the merits of that. So, the substantive difference is whether rare and irreplaceable, the burden of proof, who holds the burden of proof. I'm sorry to be slow, but
No,
in
it's-
ours, the burden of proof is on the appellant,
Yes.
and in theirs, it's on the applicant. So, what are the ramifications of that? So, and we're talking about the burden of persuasion,
Yes.
convincing someone that this either meets the criteria or does not meet. So if it's the applicant, they're convincing us that it meets the criteria. And if it's the opponent or appellant, they're trying to convince us that it doesn't. Does anyone have feeling or thoughts on that?
May I ask you just a clarifying question? You had said earlier on that when an applicant submits a complete application, Act 250 application, they spell out how they've met all the criteria, including criteria 8 and all the subsections. So haven't they already gone through demonstrating that their project meets the criteria relating to criterion 8 pertaining to rare and irreplaceable?
So, what we're really talking about when we talk about burden of persuasion is who bears the risk of non-persuasion. So so the answer is they have to provide enough information to meet the burden of production. But the burden of persuasion is more about when there is a challenge, who bears the risk that there wasn't enough information provided. So when the burden is on the applicant, the opponent is bearing the burden, the risk of the burden. So there is a bit of a presumption when there is a challenge. Are there any other lawyers in the room? Because did I answer your question? So
Yes, you answered my question. I believe.
it's a tricky legal concept, because when you declare who the burden is, it's about who bears the risk when there's a challenge. So when there's a challenge, the person bearing the risk is probably going to lose unless there has been substantial evidence provided.
Representative McCullough.
So then, that risk is being borne in the joint proposal by the applicant, as I understand this.
On rare and irreplaceable?
Yes, on your rare
Yes.
irreplaceables, yeah. Yeah, I think that's significant.
I think it protects the
Excuse me.
environment.
So my question is, who has that burden now?
I knew that was where this was going. The that's the next step. So currently, your bill is making a change because currently it is on the opponent, and your bill is changing it. No, I'm sorry. So. Yours
Just clarifying.
is, so yours is saying the burden is on the opponent for 5, 6, 7, and 8. Which is currently true. It's not changing that. We were, your committee was specifically discussing 8A, moving that to be on the applicant. That was the necessary wildlife. So it doesn't, you're not changing A, aesthetics, which includes rare and irreplaceable areas.
Billy.
Billy Coster, Agency of Natural Resources. So just to explain the joint proposal, I think what the joint proposers heard last year was that the committee was interested in moving the burden to the applicant on the natural resources criteria. Your proposal largely does that, but there is one piece of natural resource criteria in 8. It's rare and irreplaceable natural communities. That wasn't moved in your proposal. The committee last year and in your committee bill indicated an interest in moving the burden of persuasion on all the natural resource criteria to the applicant. And your bill does that 90% of the way. And the only piece that's left with the opponent is rare and irreplaceable natural communities, because that in current law is lumped with aesthetics and a number of other criteria. So what we did was we took that out of 8, added it to the rest of the natural resource criteria, and shifted the burden for all natural resource criteria to the applicant. So it just kind of cleaned it up. Because the rest of A, aesthetics, things of that nature, really are subjective, and they should be with the person opposing the project. So I think it's consistent with your intent.
I appreciate that clarification and therefore support that joint proposal. I know we heard testimony of the problems when the natural resource criteria were not on the burden of persuasion was not on the applicant. So I think this is part of the joint proposal, and I support that.
So we haven't specifically spent any time on this small issue, but that would require rearranging your criterion 8 a bit.
Yeah, I was thinking that, and
Yeah.
that maybe what helps understand why the joint proposal rearranged it, so maybe we should decide on this and then go there, look at that one more time. Okay. And as far as the I think it's clarifying language also in our draft, so I would support what Carol said to do that, unless there's a reason, Billy, that you know of not to do that. Is there an objection to the production and persuasion, the addition of sort of that clarification? I think it helps the layperson actually understand more
Right.
about it.
You know, I will run that past Matt and John, but my sense is that just clarifies existing practice. So I don't see why we wouldn't, but I will check with the attorneys.
Okay, so for our next draft, we'll look at them together, the combined with clarifying language and then the change to the burden of proof.
Yep.
You represent McCarthy.
And did I hear council say that we also, and you as well, needed to do some language change additionally in,
8.
yeah, in 8.
So now you have a choice, because we can move 8 in its entirety to have the burden be on the applicant, the burden of persuasion be on the applicant, or we can rewrite criterion 8 to match the joint proposal. So back on page 9, so on page 9, they strike rare and move it, rare and irreplaceable natural areas, and move it. So if you're interested in that, you can also move it. But it's not going to line up exactly. So you create 8B and C, which are the forest, block, and connecting habitat sub-criteria. And they establish different standards than what's currently under 8. So we have to reconcile those somehow.
No, so can I, Billy, can I ask a follow-up question to your statement about the rest of, that 8's not natural resources, but it's more subjective?
Yes.
Now, if, I'm still seeing a lot of natural resources in 8.
Scenic or natural beauty, aesthetics, and historic sites.
Well, ecosystem protection, scenic beauty, and historic sites is in the criteria 8 on the joint proposal still.
Right.
It has necessary wildlife habitat and.
So what we did was 8 is the category header. So it includes ecosystem protection, scenic beauty, and historic sites. Then we broke 8 into 3 components. 8A being scenic beauty, aesthetics, and historic sites. So that is one piece. Then B and C deal with more of the ecosystem protection pieces. So 8, our bill doesn't, it deals with 8A, B, and C, not 8, the top line criteria. Yeah. Sorry if that wasn't clear.
No, yeah, so currently it reads in existing statute, it's 8 and 8A are 2 separate components.
Alright, well, this is perhaps best taken on by you and, just the structure of it. What's best in terms of the legal structure. I don't think it's a committee decision. I think we'll make our policy intent known and then you can figure it out.
Okay, so what is can you state for me what the intent is? Because it relates to the burden, I think.
I think we agreed with the joint proposal on the burden of proof.
Okay.
And we were gonna just use our clarifying language and their burden of proof, or ours kind of together.
So
And then-
they have a separate so they've separated out aesthetics from rare and irreplaceable, and the burden is in 2 different places.
Okay.
Do you want to do that also?
As long as it comes out
Yeah.
meaning what
Yeah.
what the chair just said, yeah.
Okay.
The clarifying language, the burden switching in a way that makes sense to the average reasonable reader. What is that average reader person?
Oh, ordinary intelligence.
Ordinary intelligence person.
Okay, no, I think, yeah, okay.
Yeah, let's try that one on. Okay, and then I know, certain people are here, Kate McCarthy's here right now, to help us, and possibly Chris Cochran are here, if we have questions on the interstate interchange and the neighborhood, the downtown districts and neighborhood development areas proposal, and so perhaps we should go back to those two while they're here. I don't have any sense of if you have time limits or not, but since you're here, why don't we do that? So let's start with interstate interchanges.
Sure, so that's on page 29 of your side-by-side.
And hopefully folks kept notes and their questions about this one.
And so you may recall that in your committee bill currently, it's sort of a three-pronged set of approach for protection of interstate interchange areas. There is a new jurisdictional threshold, so that construction of commercial or industrial purposes within an interchange triggers Act 250 jurisdiction, and that is a 3,000-foot radius unless it's within an existing settlement. You also add a new criteria so that when the application is for an interchange area, they have to comply with the criteria, which uses the Vermont Interstate Interchange Planning and Design Guidelines. And then you also add a reason for denial of a permit if there is a burden under criterion 5, the traffic criterion. And the joint proposal is a jurisdictional trigger that uses a 2,000-foot radius around an interchange, but also allows for the Regional Planning Commission to determine that Act 250 jurisdiction is not needed because the bylaws comply with a set of criteria.
And I think, Kate, this might be where you come in, on helping us. I think we got to the place of understanding that these criteria were similar or the same as what had been used historically in the plan that is referred to in our proposal, the 2004 guidelines. Is that true?
The criteria that hi, I'm Kate McCarthy, Vermont Natural Resources Council, for the record. The criteria for shrinking the area, you're asking whether the criteria for shrinking the area are comparable to the interchange design guidelines?
No, I was asking, there's 10 criteria that are outlined in the joint proposal, and where did those come from?
Oh, okay. So the 10 criteria, they're Roman numerals in the joint proposal there on the left. Things like ensure planned development patterns will maintain the safety and function of the interchange area, etc.
Right.
So the idea, I will back up a little if that's okay. We know that not all interchanges are created equally, and we're sensitive to concerns about a one-size-fits-all approach. And so the 2,000-foot radius around the interchange is a starting point. But then the logic was, if there are special circumstances around that interchange that where a regional planning commission can show that good planning and development review is happening there, then in that case, should be taken care of locally. We can shrink that radius. Act 250 doesn't need to be involved. So then, how do you determine whether good planning is happening locally? That's where it comes down to these criteria. And so we said, what would we want to make sure that a local development review process is covering if Act 250 is not covering it? And that's where those 10 things came from, is looking at what types of things Act 250 would otherwise review that would be on the town's shoulders instead. So that includes things like making sure that people can get around the area in ways other than just cars. That's Roman numeral 1, and that gets at site design that makes it so maybe lots could be interconnected, not everybody's got 2 driveways. That undermines the safety and function of the roadway. That's the basic answer. Those 10 criteria they're not the same 10 criteria as Act 250's criteria, but they come from what we want to make sure is reviewed locally in the absence of Act 250. And I wanna emphasize that some of those have to do with the way things look, but this provision is about more than just aesthetics. It's also about making sure that these roadways that we've invested in as a state don't get clogged up and have to be expanded, cost the state more money, or cause safety problems. So this is about safety and function, this is about land use, circulation, as well as appearance.
So this relates to a question I have about the approval of regional plans and how that was another kind of stumbling block for us yesterday, is that there's depending on what direction the bill ends up taking, where's the best place for that to happen and how. And strikes me that this is giving authority for deciding a kind of Act 250 jurisdiction to the Regional Planning Commission. Okay, and Chris, you had something to add?
Yeah, no, you just had a question about the prior interstate guidelines, and
Did, yeah.
I think I testified last year as well as Peter Gregory. You know, they were largely aspirational, and we found them difficult to apply in kind of a site-specific situation. I think the joint proposal is a little bit more specific and more meaningful when applied to as proposed development.
Sure.
Chris, would you talk about the aesthetics of development? Seems so subjective. Is there something standard you're looking for there, or what does that measure against? On number 10, on the joint proposal.
I'm not familiar with the language, frankly. Was the intent the Gucci standard for aesthetics, or?
It was more meant, if I may, so I'll read what you're referring to, the
Okay.
10th one.
Sure.
In order to shrink Act 250 jurisdiction, the RPC would need to assure that the municipality has zoning bylaws or other standards in place to ensure that, quote, the allowed uses, patterns of development, and aesthetics of development in these areas must be consistent with the goals of 24 VSA 4302. Those are kind of our high-level land use goals. So aesthetics is one of 3 things there that needs to be consistent with the goals of 4302. Those goals include kind of the big one of compact settlement surrounded by rural countryside that you hear about a lot. It also has goals related to transportation safety, access to economic opportunity, range of housing choices. It's a very broad set of goals.
It just doesn't seem like that's necessarily aesthetics.
Those goals have less to do with aesthetics, I think, than they do with patterns of how the land is used. But then again, the pattern of how the land is used can feed into the way it looks. Yeah.
So did you all consider having this go through the Enhanced Natural Resources Board in your proposal?
That's a good question. I think that what was considered is that so really, regional planning commissions are unlikely to go out and just start doing this work around interchanges. They'll probably do it at the request of a municipality or municipalities that are affected. If they were to make a determination, say that, hey, we don't need Act 250 at all here, and then someone in that community were to say, wait a minute, we don't even have zoning. Why are you allowing that? I'm taking a very extreme case. There is a mechanism in here to appeal decisions about interstate interchange jurisdiction to the Enhanced Natural Resources Board. So that's the mechanism for accountability that's being proposed, given that, as you said, RPCs are dealing with jurisdiction. And so the way this is written, and others, please correct me if you understand it differently, the way that this is written, it's not that these get plugged into the maps in the regional plan. I suppose they should. So your question about regional plan approval is a good one, because it just made me think that this should be on maps. But it's not at the moment connected to what's being proposed.
Yeah.
Yeah.
needs to be. And the appeals section, so, I'm trying to find it, where this section shows up. Interstate interchanges, oh, 23 in the overview document provided by the joint proposers. I'm looking for that appeal, because that's not in our side-by-side, but it might be.
Right.
Where do you think that appeal language would be found?
Toward the end.
Yeah.
Okay,
Yes.
I found it. It's on page 59
Of which document?
of the joint proposal
Overview.
annotated version. It's okay.
Thank you. Appeals.
Yeah. So yeah. So yeah, it gives the Natural Resources Board appeal power over that decision.
And I think that joint proposal, does the joint proposal address approvals of regional plans? And if so, is it it's in the board structure?
I believe that when it comes to approval of regional plans, that is part of what is proposed to be studied in the joint proposal. And regarding approval of regional plans, I want to clarify that there are two things that have been discussed about that. One has to do with the approval of regional plans in general, to make sure that everything that's in the plan is what's required by statute. That's just kind of basic accountability. Today, regional plans are not approved, not reviewed with respect to whether they include what's in statute. So that's one piece of it. Another thing that you have discussed last year that I believe was in the committee's bill was the requirement that regional plans be approved before they can be used in Act 250. So those can be seen as two separate things. One is approval for accountability's sake, and the other is approval before it can be used in this process. You should consider those independently of one another, I think.
And I will confirm, it's on the study list.
Thank you.
Which one?
The approval, whether the regional plan should be reviewed and approved, it's an item for ACCC to study.
Did ACCD approve of that list of things to study?
We did.
I did, but I would sure love some help.
Sure.
And who would do the approving? Would it be the board?
Of,
Making sure all the regional plans are standard?
I think that's part of what is,
What is being proposed? Who would do it?
no proposal yet.
No proposal.
Proposal to study it and decide what the best body is, because certainly you want people approving a regional plan who know something about regional planning, and can make it a good process, not just a rubber stamp and not something overly complex either.
It would be at the state level.
It would be some level up from a regional planning commission, so that could include it could include a panel of people from the state, regional planning commission peers, enhanced NRB members. That's part of what I think needs to be chewed on in a study.
Can I ask a question?
Sure.
Good morning. I'm a bit confused though. Should we wait to decide on the conditions for approving the regional plan? until the study's complete?
Most likely, because part of what is proposed in the study is giving some thought to whether regional plans should be approved at all. So that's your threshold question, and then you would decide how that approval should take place.
So here we have a list of conditions, though, for, to evaluate development around interchanges and through the planning process. But if that ever gets appealed, and we don't have set in place, am I getting two things mixed up?
Well, currently there's no appeal avenue right now, and kind of rocked on in this situation.
I think we are kind of
Just
talking
wondering
about
if
two
we're putting
things
the
at once.
cart before the horse, should we wait? And what we see here in the joint proposal, does this need to, is this hinging on the study that we're?
I don't think it is. I don't think it is. I think that you can set forth criteria for how a regional planning commission would evaluate the jurisdictional area around an interchange. You can use those criteria for that specific purpose, separate of whether the regional plan is being approved or not.
Okay, and then my follow-up question is, do regional planning commissions already have this function of evaluating projects like this in and around interchanges? And if not, are they in concurrence with?
This would be
This
a
function?
new type of function for a regional planning commission, as I understand it, to give authority to Act 250 for one way or another. However, it is not unlike the way a regional planning commission might weigh in on an Act 250 proposal. If there's a major proposal that has substantial regional impact, the RP, or even just a major proposal, the regional planning commission may weigh in through criterion 10, saying, does this project meet our policies? But what you're talking about with interchanges is a little bit different, because the RPC, working with the town, would determine how big or small that area is. And I'm happy to say it another way, because I know I might be a little confusing.
If I may, so it sounds like the RPC already has part of their set of responsibilities. They have the discretion to weigh in on projects that fall in the Act 250 jurisdiction that may be substantial enough that has some impact on the region, and that might help to deal with some of the externalities of one development on other neighboring towns, for example. So,
Precisely.
but they have that discretion.
They
So
have
what
that
this-
requirement,
so the-
actually.
It's pretty different. So this is giving them jurisdictional authority essentially.
Yeah.
And it's a big difference.
Yeah, so that's
They've
my
been weighing in on it.
follow-up.
We have
That-
an RPC director here too, if you
Oh,
want.
we do, but.
So this is, my question is the follow-up, since they have some role, that this adds to that role through their involvement in evaluating projects within some distance of in and around state interchanges.
Yes, so I would agree with what the chair just said, which is that the first thing we were talking about was criterion 10, that describes current involvement and how an RPC would weigh in on a project. This is different because even before any projects are proposed, it has an RPC working with a town to determine whether a project is subject to Act 250, and that's a big difference. Right today, there is nothing that RPCs do to decide whether or not a project is subject to Act 250. So that's a good distinction.
Representative McCullough.
Okay, I look at that just a little differently than RPC helping the town decide whether or not the interchange would be in Act 250's jurisdiction or the municipalities. I looked at it, and this may be a distinction without a difference, I don't know. I looked at it that if the municipality had these criteria functions in their plan, then they were okay with going ahead and assuming the authority to manage that area instead of Act 250.
I agree with what you're saying.
Okay.
I agree with that statement.
It might be
It
the
is-
same.
I think it might be the same. However, it's not a default.
Right.
And it's the point is that it's a planning process.
Mhm.
You may find that you have an interstate and the 2,000-foot radius looks like this, and it may be that the local zoning or subdivision regulations that meet these criteria only apply to 2 of the 4 quadrants. And in that case, the RPC would say, okay, well, there's not a lot of protection in place over here. Act 250 should remain over here with this default 2,000. But these other areas over here, we've determined, have gone through enough planning, enough process, and will get enough local review that Act 250 needn't pull in projects
Right.
that wouldn't be pulled in otherwise.
Okay.
And I want to note that this exempts residential development. It also, if there is an
It's
exist,
a lovely place to live.
some RPCs have their areas planned for growth near the interchanges, and some municipalities do too. It also, the enactment date of this provision within the joint bill doesn't say that the day this is signed, everything around 2,000 feet around interchanges is locked down. And that was quite intentional. Towns and RPCs need the time to do this planning process. So I think the effective date for this part of it is later, to create time for that process to happen.
I'm glad you brought up the residential. So, I'm not sure why people would make a plan with residential in that area, but that brings me to the environmental justice piece, which is something to consider about where housing goes. So, there's noise, there's lights, there's,
Air quality.
air quality. And so, and which populations does it disproportionately, if it does, impact? So I just think, I keep saying this, but I think residential should be part of this. And after the explanation that you gave, I feel as though the joint proposal does offer a lot of protection about what happens in terms of the 1 through 10 pieces, if you want to call them criteria. And what else I want to say? Maybe we could put environmental justice in there. Do we have that already in there? Maybe it was on 8 or.
We're working.
We were gonna add it.
We're working on it.
The draft that we see Tuesday. it'll have-
You mean the overwhelming, but should it be part of this particular sub-piece?
I don't know.
I think that would be for the committee to discuss. As I mentioned earlier, the thrust behind those 10 criteria were me looking at, and others, looking at what Act 250 provides now that the town would also need to provide. And I did not think of environmental justice at that time because of where we were starting with Act 250.
Yeah.
I will say that I'm thinking of 2 housing developments off the top of my head, both with, one with over 150 units and one that was proposed for 274 units, and they were all market rate next to the highway. Which doesn't mean that that land would not be used for lower income housing, but land near highways is not cheap.
Even if it's a market.
Is,
Prairie Hill.
Trailer parks considered to be part of a housing project?
I'm sorry?
Are trailer parks considered to be part of a housing project?
Mobile home parks are considered residential.
Yes,
Yeah.
but are they kind of lumped in with a housing project?
When you say housing project, you
I'm
mean
thinking
something
of
that-
housing more, I don't know, more comprehensive than trailer.
Sure, so if you had a residential zoning district, for example,
Mhm.
near a interchange, it's very likely that mobile home parks could be a part of that. And if, I believe that if the number of units in a mobile home park exceeds the Act 250 threshold, that would be captured by Act 252. There's not a special per unit treatment for mobile homes in Act 250's jurisdiction today, my understanding. I don't know if I'm answering your question, I apologize.
Even be something to think about.
I'm still struggling with the jurisdictional piece, and that is, we're talking about Act 250 as our statewide land use regulation. And I think that it's a fine proposal in the substantive review of whether or not the planning's been done, but it seems to me that the agency's doing the planning, deciding whether the planning meets the Act 250 criteria is not quite the right check, and that it would go to the more natural, to the board, the Natural Resources Board. You would go to them and say, we've done our planning, we want release from this jurisdiction.
I think that's a valid question. I think that the local regulations may have been, the local regulations like subdivision and zoning or even capital plan will show whether or not those 10 interchange items are met. It's possible that the Regional Planning Commission has helped write those in the first place. It's also possible the town's done it on its own or hired a separate consultant. So the documents being checked to make sure they meet these standards are municipal documents being reviewed by the Regional Planning Commission. But what I hear you raising is a thought that maybe the RPC is pretty comfortable with what's going on in its region and would be unlikely to say, well, you know, you do have these,
Well,
you
I don't
know,
wanna, they're not as objective.
potentially.
I'm not making, they might be perfectly suited to it, or they might not.
There is no
Tom's super objective.
There is no single model for a regional planning commission. Each operates in a slightly different way.
Yeah.
Do you mind if I just reiterate the point that was made earlier, that appeals of these decisions do go in our proposal to the Natural Resources Board?
Yes.
So I think that's the check that you may be looking for.
I don't, I don't know who specifically has ability to appeal that decision. I mean, that was one of my, so is only the municipality allowed to appeal that determination?
Good question. Some of the party status, even though
Well,
there's been no.
there's been no,
I know.
No party
so
staff.
Who could appeal it?
we may need to adjust the language to clarify that if we're pursuing this.
Representative McCullough.
I propose for the next iteration that we go with a joint proposal, with the clarifying language that council just, if it would go in that spot, I don't know where it would go. But we do need that clarifying language. I think I heard we may need maps, supporting maps. Would that go in this, would that go if, well, first of all, I need to make sure, understood Kate, or Billy to say that there should be maps as part of this proposal. I may have misunderstood that.
I think that was I can't
No?
speak for everybody. We didn't include maps, and then when you asked, where does this get mapped? I didn't have a good answer for
Right.
you. So I think you may have hit on something.
There are maps that we saw that were made for the ANRF.
Yeah.
Yep, those were kind of those were the starting point maps, the
Yeah.
2,000 feet around everything.
Yeah.
If those maps were to be, if those boundaries were to be modified, where does that modification live? I think is a valid question.
Well, perhaps I would leave that suggestion out then, but I propose that we, for the next iteration, we go with the joint proposal, and I think there is some fine tuning that we're gonna get based on comments this morning, with it when we get there. And part of the rationale, I heard one of the joint proposers saying they felt that our language, using the Commerce Community Development of 2004 may not have been specific enough, and I think that's why they did this. So I suggest we go with the joint proposal. I want to also say that, and this is tangential, so we're struggling with community, with seeding Act 250 jurisdiction in downtown. And we've been concerned with sideboards on that. We might use some of these criteria that are listed in this for sideboards there, but that's a different day.
Representative LeFevre.
Oh, I would like to reiterate what Carol had to say about the environmental justice as being somewhat of a consideration. I like the joint proposal as well, but I also think that too often of course, people wind up on these interchanges in trailer parks, and so I'd just like to consider that as a.
What was that? What was the last sentence?
Of course, people wind up living in trailer parks and along interchanges.
Oh, I see.
Well, so can you both help me then understand what you mean by how that would apply exactly? I'm not following. I get your point that land may or may be cheaper, but how does this play into this conversation?
For me, I would like to have a review, not just of commercial and industrial. I think it matters where housing goes. If housing's at the interchange, if it's commercial and industrial, they're thinking about curb cuts and access for pedestrians and access for bicycles and all that. But you could have many units of residential, and what if those things aren't considered? So they're really just cut off, and they really only can get anywhere by getting in their car to get somewhere. So that would be why I would put residential in here, so it has to go through the same checklist of considerations. And even though we're going to put in environmental justice somewhere else, we could put it in here too, just so people don't forget. I don't know how exactly the law would all fit together, but I don't mind repeating it.
I'm kind of of the same opinion. I think in terms of it just fits in the sense of, it would require a developer who is doing that kind of a project to at least make some entities to, some flexibility or the same kind of standards you would provide for anyone, so that people could have the space and parking area and access that otherwise they may not get, just because it's considered more, as kind of a last resort place to live.
Carrie.
Yeah, I concur with the conversation that we're talking. And I also just want to appreciate you recognizing the time element at the local level to implement this. As you know, I'm wearing my former town planning and select board at my own town, and we can't necessarily adopt a bylaw without having it reflect in our town plan. And we know we only update the town plan every, on a periodic basis. And then there's a process for updating the zoning bylaws. So I would hope that when we think about how this would be integrated, which is, I think, noble, and I appreciate the thought going in on the joint proposal, appreciate that time element in order for towns to really understand this and see the value of it and be able to fully integrate it into both plans and
Thank you.
So I'm Tom Kennedy, Executive Director of Southern Windsor County Regional Planning. So in other committees in this building, we're actually trying to relax housing standards so we can get more housing built. Just remember, single-family housing is a permitted use under statute, and so if it's a small development, it doesn't trigger Act 250. It's a use by right. So, and I understand all the issues associated with environmental justice and so on, but I just think I'm just cautioning you as far as what you're trying to do here, because someone could put up 4 or 5 units and it may not trigger it. So.
one other question. You do run into the occasional interchange where a town has historically grown in and around that town. And wanted to be mindful of that, because that is their town, that is their growth center, that is their downtown area. So, and I'm, thinking of, exit 9, Middlesex, exit 10, Waterbury, those, so I'm interested to make sure that we are mindful and not have one size fit all, when we have a reflection of that historic growth and development that are condensed and compacted and have all the type of growth that we like to see, but they happen to be adjacent and within these the radius that's described.
Yes, thank you. I believe that in our definition, we intended to exempt anything that was within that 2,000 feet, but a designated area. So a designated growth center, new town center, village center, downtown, or neighborhood development
Thank you.
area.
Terrific.
Yeah,
So
that's
our
an important point.
side by side doesn't show that definition.
No.
We have a definition that recognizes existing settlement.
Let me follow up with that and make sure that it's in there as we intended, because that was part of our discussion.
The existing settlement is different from the state designated.
Oh, I understand. I hear that that's different, but I don't see a definition. It may be there, but I don't have it here. Tom?
I have to ask a question, directed to Carrie. Carrie, do you find exit 10 to be offensive, or?
No, I don't.
Okay.
What I'm interested in making sure that we're not inhibiting or preventing Waterbury to continue to grow in and around where they currently have their growth center, but they happen to be within this radius. So that's, I wanna make sure that we're being careful and not having a burden on the town of Waterbury. So
Okay, I just wanna know where you're coming from, so.
May I add one more thing? We talked about appeals, and the question was raised, well, who's allowed to appeal if they don't like the bubble that's been drawn around the interchanges? And on I found an answer to that. On page 60 of the Act 250 discussion document dated January 14th, it says, an appeal under this subsection may be brought by any person aggrieved. Person aggrieved is a defined term in Title 10. And I'll read that if you want it. It's the particularized interest standard. It means a person who alleges an injury to a particularized interest protected by the provisions of law listed in section 8503 of this title, etc. So the person, I'm going to prefer that an attorney type really talks about this, but you have to demonstrate a particularized interest, you have to show that you have an interest in that site and would be harmed. Have the potential for harm. So there is a standard. This is different than the standard that is used for most appeals, but it's a standard within Act 250 saying who can get involved in a case. I would be happy to be corrected by Alan if I'm wrong about any of that. She's an attorney type.
But it is used also in the concept of, or the act of granting party status.
That's right.
And so it would be interesting to see how that was interpreted in a case like this that doesn't have a same process.
Right, it's more like party status would be determined at the time of appeal.
Which may or may not work.
That person would include the municipality.
It would,
Yeah.
it would.
Presumably though, they asked for the, I guess they they don't like getting denied, they could be denied.
Or they wanted a bigger area, not part of Act 250.
Okay, seems like we are, supportive of the joint language in overall, and that we should put that in and then consider some of the things we've talked about, when we go through it again.
So you wanna take out the criteria and the permit condition denial, in addition to changing the jurisdictional threshold.
I'm sorry, I didn't hear all that.
So yours includes the jurisdictional threshold, the permit, the criteria 9I, and then denial of a permit. So do you wanna replace all of that with the changing language for jurisdictional threshold or just,
Oh, I see, right, yes. No, I
There's
don't,
a-
I don't think you can really, right? I mean,
no, you can, those are independent.
so,
They don't in any way address whether there should be a separate criteria for interchange areas.
right,
They don't address whether or not a permit should be denied based on, undue impacts under criterion 5, the traffic criterion.
right. So they're not mutually exclusive was what I meant.
Okay.
Um, And I mean, I guess I'm thinking, don't you kind of need both? Because if you haven't been exempted, this, ours actually sets up a process for approval of the development at an interchange. Theirs doesn't, through Act 250. So I think you might need both.
Yeah, I think so.
If I might include making sure we have the language in there about existing designated areas and settlements that we just talked about. So that we're not burdening the towns like Waterbury and Middlesex, for
Right.
example. And making sure we have the dates in place so that towns have the opportunity to do the right planning and integration into zoning bylaws, and that takes time. So we'll have to make sure that that's in place.
So that's why I started my line of questioning about where did your criteria come from? Because if a town hasn't gone through this process and hasn't been granted the approval, then what happens in an interstate interchange under your joint proposal?
Under the joint proposal, the 2,000-foot radius around the interchange is subject to Act 250 until the town has gone through these processes.
Okay, so but I'm not sure that's clear.
So is it?
Maybe that because we're looking at sections of the bill, so
There's
I don't
the
know.
unless word.
So can I just
It's
clarify?
it's the
So
unless.
our proposal is a jurisdictional proposal.
Yes.
It adjusts the definition of development for which Act 250 jurisdiction is triggered to include this area. So it basically means if you're in this bubble and you're non-residential and the planning process hasn't happened, you trigger Act 250 jurisdiction. Then you just go through the normal Act 250 review process. You don't need an additional criteria for it. It's just like any other form of development that would flow through the review process.
Right. The addition of thank you, Billy, that is true, I agree. The addition of a criterion I sets forth additional standards of review that need to be met around interchanges that don't need to be met anywhere else. And those are the standards and the ideas in the interchange planning and design guidelines. So I think I'm agreeing with Billy when I say that so long as you bring those interchange areas under jurisdiction and they go through the same Act 250 process as everybody else, you don't need the criterion 9I. You don't need those supplemental standards.
I see. So multiple layers of things getting conflated in some instances here, because right, okay, got it.
Yeah, but that distinction between a jurisdictional change, what comes into Act 250, what doesn't, versus a criterion change, how something is reviewed in Act 250, that's an important distinction. I've been talking about jurisdictional. You know that.
You know that.
You know that.
At this point, we got that one.
I just sometimes say really simple things.
Did you want to say something? Oh. Okay. I'm also gonna say that to you that I think, it is our intent to include this, we also have a jurisdictional trigger, and it's fine with me to go with the 2,000-foot one, in the joint, because I'm hearing support for the intention of the joint proposal around this table. But I also think that it's gonna require legal minds to structure this appropriately. So however that comes out in your draft would be reflected. So I guess, we're not gonna use the 2004 guidelines. I think we share the intention that we're creating a jurisdictional trigger, and that if you trigger Act 250, you just go through the normal criteria. I agree with that. And then that there's also a process for how you could apply your local planning and avoid this jurisdictional trigger. I'm not totally comfortable with having that go through regional planning commissions, but that choice. But for now, let's leave it and look at that language in the next draft.
Did also Representative Dolan just ask that we add that designated
Yeah.
areas also be exempt in addition?
Yeah, and I think, did you guys find a definition that you have in yours, or it just wasn't?
Because I think your current version, so it's construction of improvements around an interchange area unless it's within an existing settlement.
Yeah.
Includes designated centers and other areas.
So they changed that to a designation,
Okay.
which is, I guess, the intention. You would put all of them in there, all of the designated 5 areas.
And somewhere in Act 250, there is kind of a bundled definition of designated area that can be referred back to. That includes this one.
So that's why I say, like, structurally, we're gonna use, like, ours might be some, from what I'm seeing right here on the page before me, ours seems cleaner. It might be that it exists somewhere else, but Representative Cohen.
Thank you. I'm thinking that we have maintained the capability, or no, the requirement that development and interchange areas go through Act 250, except for what we've just agreed on for the next iteration, except for the municipality's ability, based in their plan. Which also gives Act 250 the ability in the cases that Kate mentioned, where 2 quadrants would be under the municipal aegis, and 2 would be under Act 250 because of the proposal, or even the current land uses there. But then I think I just heard that we don't have the jurisdictional trigger anymore. Did I hear that?
No, we're clarifying that we do have it.
Okay, good.
We agree that it should be there.
Good, good.
I think one outstanding question, which we can talk about again, but 2 people have brought up housing and how it's treated here. But I think the underlying thing with the housing is that it's currently out in both of the proposals, and I know that some people don't agree with that. So we'll think about that.
One thing I should mention, again, team, please clarify. This does not create an exemption from Act 250 in those areas where the municipality has shown it meets the standards we've been talking about. What it means is that there won't be automatic inclusion. If you still have, commercial development on over 10 acres or the triggering number of units near the interchange, the normal Act 250 standards apply. So we're not talking about an exemption.
Yeah.
We're talking about lack of inclusion, not an exemption. So just want to be really clear about that so nobody misconstrues it.
Yep, thank you.
Get it.
That helps me
Okay.
understand.
Okay.
Let's move on to the downtown neighborhood development area.
That's on page 26.
Thank you.
Currently in your, our discussion, I believe it was yesterday, was that you are interested in having the automatic exemption for development in designated downtowns and neighborhood development areas with the ability for the existing Act 250 permits to be extinguished for those areas also. So I have written down that you were interested in pursuing the joint proposal.
Okay, I think we have questions that will percolate forward as we kind of reopen the door with Chris here. I have one, I think, that I'm hoping I can still even understand, but on page 27 in the left-hand column, in the middle of it, C, federal or state law that's no longer an inspector applicable. What is that getting at?
We looked at a bunch of Act 250 conditions, and there's just a whole range of universe of things that may or may not continue to apply that are still subject. So, it could be a HUD requirement that's no longer required anymore, or just federal law. Things change. Some of these permits can be 50 years old, so things do change. So it's just something that the municipality is asked to flag and evaluate, and if it's no longer valid, they shouldn't need to retain that condition. It's effectively moot, so why would you continue it?
I just was,
Yeah.
I couldn't think of any myself, so.
Yeah, I don't have I'm sure I could give you a specific example, but just looking through, pages of conditions can go on for quite a few, so. And it would only apply if the law is no longer valid, so.
Folks have memory of their other, we had a good conversation about this yesterday, but as I recall, there were questions, so. Outstanding questions.
So changing to the joint proposal, your bill currently was an enhanced designation process for a greater number of the designated areas could apply for enhanced designation. So you're focusing in on just the designated downtowns and the neighborhood development areas. So I think you might have had questions about those two areas. But
Well, I guess, thank you. I think that we were, if Chris, you could explain the different, like how those designations happen and that distinction among them. That's right. Thank you, Alan.
So we have 23 designated downtowns currently. These are principal large areas that everybody recognizes. Brattleboro, Burlington are larger communities. The process to designate them is just the designated commercial core. So in Montpelier, it is just the downtown area. It tends to exclude, although there's occasionally some mixed uses with housing above and commercial down below, the residential areas. So it is a program that was created to target tax credits to improve these buildings. These buildings were run down in many of our communities, and it created a geographic area. This is our historic center. This is where our commercial activity happens, and this is where we like to target these tax credit investments, because we didn't have a lot of money, and we wanted to make sure the investment was concentrated. In this framework, this is different. This is looking at these areas as places of traditional investment, areas with limited resources, natural resources, because they are highly developed. And what we're saying is everybody pretty much agrees that these are areas where we'd like to see concentrated development occur. These are areas that are larger communities with planning, staff, and capacity to regulate. And many communities have been frustrated that they can approve something locally, and it gets, Montpelier is the example here, is their parking deck, and then we'll pass a bond for it, and then it gets caught into an Act 250 deal, and we would like to be able to be supportive of what the community would like to do in their own backyard. The evaluation process for the designation, they have to have we find if you just make the investment in the buildings, it doesn't necessarily bring the vitality, so the community has to have a local nonprofit group that supports the mix of businesses and the overall vitality of the community. The community has to have a commitment to historic preservation, because we're making investments in these tax credits, and we want to make sure that that's going to be protected. The community has to prove that it has existing water and wastewater capacity to support new development. I can walk you through the application I have in my pocket if you want.
That's okay. We don't.
But the intent is, we all agree these areas, places that should see additional development can support additional development. We want to be able to trust the municipalities and their ability to regulate in these areas. Neighborhood areas, well, I'll stop there. Are there any questions?
Yeah, Matt has a question.
Well, not necessarily about downtown. I kind of have a more of an overarching question, and we talked about it a little bit last night, or yesterday. Why stop at downtown and neighborhood development areas? Just looking at my neck of the woods. Johnson has a village center, so it's that park. From what I hear you say, village centers normally smaller, may not have the capacity to handle oversight.
Yeah.
But I think in many of these village centers, there's a lot of room for improvement on the building.
Well, that's where you get you anticipate the next thing, that we're talking about the neighborhood areas around them, which would designate a larger area. For village centers, it's roughly a quarter mile, or essentially a walking distance area around the underlying downtown designation or village center designation. And for downtowns, the neighborhood area is larger. It's a half-mile radius around the downtown village center areas. Our other designations, new town centers, growth centers, can also achieve this neighborhood area designation. So there is a way for each of the designations to create a little bit of a larger exempt or jurisdictional change in those communities. So in both your cases, I said Johnson and Hyde Park, they have sewer and water capacity. There's an opportunity to develop there. They just have to make sure that their bylaws can be brought up to state standards, and
We really have some.
and that's usually
Hyde Park
the,
does, Johnson does not.
and that's usually the challenge. We're releasing jurisdiction here, and if the community doesn't have zoning or has form-based zoning only, it's probably not going to meet the requirements.
You just said what is the relevance of the half mile around the downtown?
It's a generally considered a walkable area.
But it's not included in the exemption.
Well, the way stepping back, I do have some graphics here. I don't know if it would help. We create these buffers on our maps, so the downtown is a very carefully, parcel by
Right,
parcel.
we have a link to the downtowns in
Yeah.
the atlas.
A buffer is created around the downtown's half-mile buffer.
Yep, that's in there too.
And it just says, this is your neighborhood planning area. Look in these areas for where are your neighborhoods, and where do your bylaws meet the state level standard for the designation. And those are the areas where you should designate. Communities can designate areas that are smaller within there, a subset of those areas, or maybe only a portion of their bylaws meet the state standard, so that's all they can designate. Or in the North End in Burlington, they wanted to make a bigger area. And if you drew our bubble around Burlington's downtown district, it was all of Lake Champlain. So they looked at the facts and circumstances on the ground, and they delineated a larger area because that's where their neighborhoods were, and that's where the benefits made sense. Currently, the neighborhood development area benefit is aimed at new development, supporting new development. In the Senate and in the House, we have a proposal that's going to create or expand our tax credits to these neighborhood development areas and allow rehab of rental properties within these areas. So that should be a significant incentive to help communities update their bylaws, in addition to releasing them from jurisdiction and then creating an incentive to improve the quality of the housing stock within these areas. I think is a powerful incentive to make sure that communities voluntarily bring their bylaws up to a higher standard.
One more. A downtown area can have their neighborhood development area, could a village center have a neighborhood development area?
Absolutely, yeah. One of the fundamental requirements, and usually the bigger challenges for villages, is you have to have wastewater
Yeah.
to support the densities that we're looking for.
Yeah.
However, there's a Westford as an example. It's kind of, you build it and they'll come,
Right.
You have to have the wastewater systems to support the development. So the developer's not gonna look at the community unless, So we had a long conversation with A&R. So if a community can design a system that is approved by A&Rs, this is the case in Westford's, they can qualify for the neighborhood development area designation. They have to have a plan showing where that wastewater is going to go.
And Johnson's all backwards. Johnson's a great wastewater system with capacity, but
Amazing.
but
No
no,
planning,
but
But
it's,
there's a moratorium underwater, isn't there, or something? One of the, Jefferson, it's Jefferson,
Okay.
yeah.
Gary?
I'm thinking of even smaller towns without wastewater, which are the towns in my jurisdiction. But at least we have water, but we have these decentralized wastewater systems, and I know that there's still room for more. So if we were to try to go through a village-based neighborhood development area designation, is this a path forward to help towns smaller towns in rural settings similar to mine, where they don't have a wastewater treatment plant per se, a large box, but they have the potential for developing maybe a smaller decentralized system?
You can designate a tiny little area and then add to it as capacity grows. There has to be either water or wastewater capacity to support a minimum of 4 dwelling units per acre.
Okay.
And there's places, Warren and Waitsfield that do that.
Right.
And if you wanted to designate a larger area, you would have to design a plan to treat the water or supply water in this newer area that A&R would approve, and then you could get a larger area designated to support some prospective new development.
Okay, and will there be state revolving funding available?
It's
Do you know, to
available to all
help support
communities.
semaller communities to be able to finance something?
A&R
like-
standards recognize the designation and give them a preference, but to what degree, how that preference sugars off when you're competing against many other communities, I can't speak to.
Thank you.
Sure.
So these little towns, in which the downtown is pretty much characterized by a church or a gas station, maybe a general store, would they fall under this umbrella of exemptions as long as they had zoning and a town plan and things
So,
like that?
a village by itself is not gonna be qualified for the Act 250 exemption. A village with a neighborhood designation on top of it would qualify.
So they would have to take an extra step.
Right.
And that would be, they achieve that by going through,
Through the neighborhood development area designation process, which looks at the local bylaws, looks at the water, wastewater capacity, it looks at natural areas and plans to protect those from development. There's a whole long list of checklists.
would that be like like in my neck of the woods, would that like be NVDA, the Regional Planning Commission?
NVDA would assist you with this process, absolutely.
But without that, there's no
Well,
pass.
it's a good point. One of the things, right now, we only have 6 neighborhood development areas designated. They're mostly in Chittenden County because, again, as I mentioned, the benefit is to support new development. In your part of the state,
Yeah.
what you need is investment in your existing housing stock. We worked with AARP, VHCB, and the Realtors Association, and brought a national consultant here to create model bylaws with different typologies from a larger, medium-sized to a small hamlet. How do you create some bylaws that allow a community to kind of easily get through this process? So somebody like NVDA would be able to kind of take these off the shelf, tailor them to a smaller community, and they would be able to get the exemption more quickly. And again, the proposed additional tax credits to support housing improvement would be the real benefit in your parts of the state, and most places outside of Chittenden County where just not a lot of new development is happening, but where we'd like to see more investment in existing housing.
Okay. I think we've agreed we're gonna keep the joint language in for the next round, and I'm hoping, do we have any more questions for Chris on this? Anything
Sorry,
else?
I'm not in uniform. This is my coat and this is my tie. So I wasn't planning on being here.
That worked for me.
Thank you for coming in, Representative.
Yeah, Chris, so this would be the place if we were to put sideboards on the municipality's ability to have a responsibility instead of Act 250. So I guess what I'm asking is, have you considered any, one of the questions that was raised in earlier testimony of, well, okay, but Act 250 looks at surrounding areas as well. Whereas a municipal bylaw is more focused on its own boundary and own project. And so there may be some sort of sideboards that we want to add to this. And depending on what they end up being if we did it, is this thinking?
Well, I think a little bit, you're thinking just on a municipal level. I'm thinking of just the little overall larger joint package. What we're talking about here is jurisdictional changes within these centers that
Yes.
we all recognize we'd like to see more
Yes,
development
yes.
happen, paired with jurisdictional increases in areas that we'd like to protect outside these areas. So increased jurisdiction in important natural resource areas, and reduced jurisdiction in areas where we all agree that development should occur. So that's the kind of sideboard that is envisioned in the overall package. And I don't know if that speaks to your question.
No, I don't think it does to me. Yes, we are trying to increase some jurisdiction in other parts of the state, which is what I sort of think I just heard. But what has been raised in the room is that the decisions that are made in that municipality, by the municipality, instead of Act 250, may not be cognizant of areas outside of that municipality. Let's look at exit 12 in Williston, and back in the day when the mall wars were going on, and we really were trying to consider what the impacts of all this
I
commerce
think I
would be.
understand. So the regional impact is not being considered.
Right. On the region.
Well, I would say, regional plans are asked to consider, looking at adjacent regions
Well, yes,
and the
they
effect of
are.
those plans as part of that process.
Yeah.
Well, this- Can I, if I may, just a big example that struck me was the impacts of traffic for like Cambrian Rise, which is a very large development. And it will affect the towns north of it, and I guess it just, I mean, I'm not questioning the foundation of this, I think it's great. But what is the, where would that get reviewed?
Traffic at the local level, it wouldn't be reviewed by Act 250, obviously, because they would be exempt.
Yeah, and there's no review at the RPC level either, and so it's sort of like, that's just something, that's something out there.
And personally, I feel like, please, more traffic, and that'll force everybody out of their cars and onto their bikes and walking. But it's a fair point, like in Burlington and Winooski are right next to each other, so what happens in one community doesn't affect the
Yeah.
others. How you resolve that, how Act 250 actually resolves that, I don't know. Act 250 denying a housing development because of a traffic concern, creates a different
Which we
problem.
don't do.
Yeah.
Which is not possible.
Yeah.
So, that's
right.
right, it doesn't happen today,
Yeah.
so that's a good point. Carol?
Oh, I was gonna say, it's not just Burlington Whiskey, it's Burlington, it's Colchester.
Yeah.
Colchester's impacted, people coming from the islands are impacted, everybody's impacted.
All right, well,
But we're also impacted by scattered development
Yeah.
as well, so.
makes more traffic, yeah.
Yeah.
Yeah, right, okay. Thank you.
Thank you. And I'm sorry I haven't been here. We have a big housing bill and it's been quite consuming, but if any questions come up, you always know how to find me.
Yes.
I'd like to underscore something Chris just said. I appreciate and understand that you're looking at the downtown and neighborhood development area exemption to understand the policy of that exemption. As we put it forth, you've probably heard from others in this joint proposal, the idea behind that exemption is that we are making it easier to do development where we want it to, but it must be paired with a balanced approach to protecting more sensitive areas outside. So we're talking about this as a standalone piece, but like everything else, we're thinking of it as a package.
And I guess since you're here, I would love your assessment of where you're at with the housing community, the affordable housing community. They want to come in next week.
Yeah, I mean, without going into, there's a concern about exempting, if downtowns, right now, I should back up a little bit, right now, affordable housing projects get preference through the priority housing project exemption within the designated areas. So if they meet these affordability standards, they do not have to go to Act 50. What we're proposing here is to level the playing field. We're saying all types of development is enabled to enjoy this exemption. And they have a concern that the exemption is going to lead to gentrification in many of our communities that are designated. And we've had extensive conversations started in December to consider ways to address their concern. The conversations have been productive so far. I'm confident we're going to find a solution. I think what we're looking at is ways to change the designation process to ensure housing interests are considered when communities are designated or redesignated. And we're very close, but the conversations continue. But the Affordable Housing Coalition is working on an updated proposal for the administration to consider. And maybe I'm just an optimist, but I do think we're going to land a plane on this one.
Great, thank you for that, very helpful. All right, next up,
Ridgelines.
Ridgelines.
Back at the beginning. Page 1? Page 1. So, to remind you, I don't think we came to a decision, although maybe someone has in their notes the two different proposals. Your bill currently has a definition of ridgeline, and it is then used as part of your jurisdictional threshold in critical resource areas. So, you amend the definition of development as a jurisdictional threshold to include construction of improvements for commercial, industrial, or residential use at or above 2,000 feet, or in a critical resource area below that elevation, which includes ridge lines. The joint proposal does not have a, does not change the elevation, the 2,000 feet aspect, but it does add a jurisdictional threshold for construction of improvements for commercial, industrial, or residential at or above 1,500 feet within 200 feet below the elevation of any portion of a ridge line. So a ridge line at or above 1,500 feet, and the 200 feet within the ridge line is the jurisdictional.
So, yeah. I guess I'm personally having a hard time with both of our attempts at the ridgeline tool. I appreciate the effort very much in the joint proposal, but I'm not sure how it would be administered. And I think we have taken compelling testimony that the elevation between 2,000 and 2,500 feet is critical for adaptation of species. So I guess I'm leaning towards having a change for jurisdiction to 2,000 feet, not for forestry and agriculture, but for development. We have mapping analysis of that shows that a lot of that land is already under Act 250 jurisdiction actually, and or already conserved, but there is, a meaningful portion that should probably be conserved at that elevation. And it seems like a bright line, to use Ed Stanik's term. It's worked at the 2,500 foot elevation. But I put those thoughts out there to begin the conversation with all of you. Jim?
The ridgeline mischief that got introduced in this room last year is no small part mine, and probably my carpool mate, Representative Squirrel, but so I guess it's I got a little tear on my cheek by ditching the ridgeline, but I think the wisdom that it's somewhat difficult to pin down, somewhat difficult to even visualize for people, and difficult to perhaps to regulate. Which I'm pretty much parroting what the chair said now, I think, on purpose, and so the 2,000 just ditch the ridgeline concept, Jim, and go with a really straightforward bright line, which is 2,000 feet for the next iteration. There may be a push for dropping that to 1,500 feet at that point in time, but for now, the decision is this or that, and I think the next iteration, we need to make the changes necessary to cross out both of these sections and ensure the 2,000 feet in our next iteration.
Tom?
Are ski areas exempt from Act 250 or?
No, they're mostly in Act 250 jurisdiction already. When you look at the map, it's,
And they also have master plans, right?
often, we learned yesterday, many of them have master plans.
So it's like an ongoing development for them.
Thoughts?
Yeah, sure. I'm fine with going to 2,000 feet. And once we get to the one bill, I'll be happy to hear. I'm assuming the NRC are the ones that wanted the 1,500 to 200 foot drop. I don't know, but we'll have to hear from them when we get to one bill.
Try this one on for size.
Yeah.
With agriculture and logging exempt,
Or not included.
not
Yeah.
included.
So retaining the 2,500 foot for
as it
farming?
is.
for farming and forestry? Okay.
I don't know why we're going to something higher than what the joint proposal says.
Well, the joint proposal is 200 feet down from those ridge lines, and it ends up being, when I look at the maps, they're pretty, I don't know how you would pick, I'm not sure how it would be implemented.
All right, bright line.
Yeah. And I think that means we're also moving away from the critical resource areas being called out in the bill overall. So there'll be some structural changes on that. Okay. Any others that you know
of? The critical areas are the ones we identified a year ago in our bill, in the committee bill.
Yeah, well, we had this.
Then it changed.
So many of the critical resource areas, so we just kept 2,000 feet for jurisdiction. We just deleted a ridge line, and there's lands characterized by slopes. We also took testimony similar, to the ridgeline tool that was developed. I asked if that encompassed slopes, which I think it does, but we didn't get total clarity on the answer. Act 250 in its inception refers to sensitive areas on steep slopes as not being great for building. And I think if we keep in mapping for the capability and development plan, that's going to help people understand where those steep slopes are. And it's not jurisdictional, but it's informational for district commissions to, it can inform their decisions as they review an application. So I think that's the intention of seeing the pieces coming together that way.
And we're still kind of in the process of identifying what a river corridor would involve if you had a river corridor on your land.
Well, no, we're going to use the joint proposal for the river corridors. That's in there.
So for me at least, the original idea of river corridors throughout the state being an enhanced resource area is gone.
And the other one that's missing is significant wetlands. Although it's not in our definition here, we had, in our underlying bill, we had wetlands. So how come it's not in the definition here? Or what?
What definition?
Page 1, critical resource area.
Yep. Music.
Oh, significant wetlands. It's because it's the first one, and I wasn't reading the whole thing. Sorry. Okay, and that I think is that we have structure already in place to evaluate impacts to wetlands. That was the testimony we took last year on that. All right. Where did we go next?
So I think the only other thing that we haven't decided on is permit presumptions on page 22.
And you were going to give some clarification, Billy.
So I did hear back from Matt Chapman and John Grogman, and they confirmed that your language about the initial burden of production just clarifies existing practice. It doesn't change anything, so they're fine with that language.
Okay, thank you. And then on permits, did you get that list?
I have the list from Matt. I have someone working up right now which of those permits currently enjoy a presumption under the existing rules and which would be new. I don't have that done yet.
Okay, when might that?
Certainly by Tuesday.
Okay, great. And understanding who's the right person to help us understand all the A&R permits go through Administrative Procedures Act through ICAR and LCAR, right?
Yeah, and their own rulemaking, yes. So
that's their rulemaking. And
Yeah.
then I guess that's why I'm trying to understand the interplay between the NRB review of permits. Like, that's basically you're saying, I think the joint proposal is trying to say these permits have really already undergone public review and doesn't need to go again, but I don't understand what happens at the NRB and I just want confirmation that all of those permits have already gone through LCAR.
Sure, we can get confirmation of that and have the NRB talk about what their process is for those. That'd be great.
Yeah, you may want to hear how they evaluate, but it involves sort of matching up if a specific permit directly addresses what is described in the criteria and whether that is related. So, you know, a stormwater permit, how does that relate to the criteria under 1 related to water pollution? Is that something that addresses that criteria?
So that provides guidance really to the district commissions more than anything else, it sounds like.
Well, so the adding a permit to the list of things that get a presumption allows it to be used as evidence with a permit application that carries the presumption. So when an application is filed, they have to address all the criteria. And if a permit comes with a presumption, it can be used as evidence addressing the criteria. If it doesn't have a presumption, they can show that they have received the permit, but they also have to provide something else in addition to it to demonstrate that they've met the criteria. Some sort of other statement by an expert or other testimony that in addition to this permit, they have met the criteria, that they haven't caused an undue burden or an undue impact. So you can potentially ask the NRB to describe, but they are looking at whether what is in the permit addresses what the criteria is addressing.
Doesn't that add I guess I'm now wondering why doesn't that help people to have that review and sort of guidance?
I would have to understand more how, like, what review the NRB actually does with that. Our position has long been that there is rarely a one-to-one correlation between an agency permit and an Act 250 criteria. And our position is that we think that the agency permits should have a presumption for the ground that they cover. So everything that a stormwater permit explicitly addresses should enjoy a presumption that can be rebutted. Anything outside that permit that falls under Act 250's water criteria is Act 250's to deal with. So we're not suggesting that these permits would have a one-to-one relationship with the criteria. I don't think that's the existing practice now. I think the rule kind of suggests which Act 250 criteria those permits generally nest under, but it doesn't say that you've 100% covered. It provides Act 250 still with room to raise other issues outside of those permits. So, you know, we could certainly create some sort of crosswalk between the permits and what criteria they would typically be considered under, but it's not as like direct and linear as you might suggest, with the exception of maybe wetlands. But even then, you know, our permits only deal with significant wetlands, class 1 and 2. Act 250 looks at class 3 wetlands, for instance. So there's still that interstitial space that exists even under that criteria.
Okay.
But I can get someone who knows much more about this to come in.
Sure, and under Rule 19 of the Act 250 rules goes through and list which permits can be used for which criteria for that presumption.
Great. So does that get us through everything? Except you have new language for us around
Oh, the board.
the board. But Jim, what were you gonna say?
That got us through everything
In the joint proposal.
in the joint proposal.
Oh, right, we have our
But we've
7.
got our not addressed that we need to address this afternoon.
We need to address that this afternoon and take up the language that Ellen has drafted for us regarding the board, the district commission, sorry.
District commissions.
District commission and appeal on the
Got that.
I need one. All right,
And
let's
the
recess for lunch and come back at 1 o'clock.